Hey guys, today I'm reading again from Suits and Chancery by Henry Gibson. I'm on Maxims and Principles of Adjudication, section 60, and I'm going to start to read now. No one should be condemned without a chance to be heard. This is a fundamental maxim of equity jurisdiction and has always been sacredly observed. Indeed, it is a principle founded in natural justice and of universal application, that no man can be proceeded against in court without notice. The inherent love of fair play contained in the maxim has always and everywhere been recognized by all judges and courts, and the practice of all tribunals is to render judgment against no one without giving him a chance to be heard in his own behalf. The law delights in giving to every man a day in court to make his defense. See, man, not person, man. But I just wanted to point that out, right? Let's just remember that. Where the law otherwise no right would be certain, no property safe, no possession secure, fraud would revel in triumph, and trickery be supreme over good faith. No principle of the common law is more sacred than that no man shall be deprived of his property by the judgment of a court without personal notice that he has been impleaded therein. Where the defendant cannot be personally notified in the suit against him, but has property within the jurisdiction of the court, the law deems it not just that he should enjoy his property or its proceeds free from the just claims of his creditors, and so the court will substitute a seizure of his property and a notice to him printed on a local newspaper that he has been sued, in place of direct personal notice of the suit. But even in such a case, so anxious are the courts to do everything in their power to give the defendant actual notice of the suit against him that they require his property to be actually attached. Attached usually means lien, from what I understand, and due publication thereof to be made before they will dispense with the service of a subpoena upon him. In such a case, the attachment of his property and the published notice are substituted for an attachment of his person in the cause. So a lien on his person in the cause, or at least substituted for an actual notice by service of a subpoena. The notification to the defendant that he has been sued, made by service of subpoena or by attachment of his property. Again, I think that attachment, I've learned that it means by lien on his property, and publication, or in some specific causes, by publication without attachment, is essential to the jurisdiction of the court over his person. And if the court has no jurisdiction over his person, actual or constructive, it has no power to render any decree against him in personam. Wow. Nor against his property, even when the property is within its jurisdiction. So if they don't have jurisdiction of the person, right? They have jurisdiction of the person, then they can't have jurisdiction of the property. And when the property, says right here, see, nor against his property, even when the property is within the jurisdiction. But any such decree will be absolutely void. It's very, very interesting. Let me read this part right here and see what we put. There's always some juicy stuff in these lower sections of footnotes. So it says here, no one ought to be condemned unheard and unsummoned if he be not contumacious. Interesting words right there. Let's see. If the defendant evade or attempt to evade the service of the subpoena, the officer shall leave a copy at the usual residence of the defendant, which shall be sufficient service. The defendant will not be allowed to take advantage of his own contumacy. Contumacy. What is that word? Contumacy. Let's see. Contumacy. Let's see if we can. Contumacy. Stubborn. Refusal to obey or comply with authority. Okay. That makes sense. Makes sense. The defendant will not be allowed to take advantage of his own contumacy, his stubbornness to avoid. Okay. Let's see down here. This great principle. This is talking about 93 right here. 93. Where is it here? Talk about this one right here. This section here. No principle of the common law is more sacred than that no man shall be deprived of his property by the judgment of a court without personal notice that he has been impleaded therein. And that's right here. This great principle, which has always been considered so important to the safety of the citizen, has been violated in but few instances, and in those only where the evils resulting from requiring the notice would more than counterbalance those arising from proceedings without it, as in cases of attachments of property, motions against public officers of the state, and of sureties against their principals, and such violations are watched with great jealousy, and the statutes authorizing them are strictly construed. A man's property is, in a sense, a part of himself, and when his property is seized by another, he is presumed to know it, the property being in the possession of himself or agent, and the knowledge of the agent being considered the knowledge of the principal. Sheesh. Incredible. Well, this is section 60. I'll be reading this in my next video right here. Section 60 of, let me show you. Here we go. Suits and Chancery, a treatise in Suits and Chancery. Setting forth the principles, pleading practices, proofs, and processes of the jurisprudence of equity, and giving numerous illustrated forms of pleadings, writs, orders, reports, decrees, and other proceedings in Suits and Chancery from their beginning and their end. Henry Gibson. Peace.